Chalo. So, good morning everyone. Let's start. So, in the last lecture, we have revised. We have finished two chapters, right? That is KMP and board meetings. So, आज हम क्या करेंगे? So, today we will start with general meetings. Okay? We will do general meetings. Then let's see. As per the time, we will go with the next chapter also. Yes, so please come to chapter number 13 from your ICSI module. चलो Chalo. So general meetings, right? Last lecture we have already done with board meetings. So what is general meeting? You all know that. इसके अंदर we talk about three types of meetings: AGM, EGM and class meeting, right? इतनी बात होती है इसके अंदर. Now in general meeting we start from section number 96. Right, I already told you this three types of meeting: AGM, EGM and class meeting. So the first section is 96, which is talking about AGM. Okay, yes. So what is AGM? Let's go. So friends, AGM, the name itself says this is an annual meeting. This is annual which meeting? Members meeting, means shareholders meeting, right? Yes. Now the rules related to AGM starts here. Come on, it's AGM. So how many meetings in a year? One meeting in a year, right? So it is held once in each year. Which year? Financial year, calendar year? It is calendar year. Very simple. Now, first AGM of company should be conducted within how much time? 9 months. 9 months from the date of incorporation? No. 9 months from the end of first financial year. That means if your company is incorporated in whatever date, your first meeting should be conducted within 9 months, but 9 months will start from 31st March of that financial year. Okay, it means that it is not necessary for the company to hold AGM in the year in which it is incorporated. Okay, the year in which company is incorporated, AGM is not required to be conducted necessarily, compulsorily. Okay, fine. But you know, when we talk about the first financial year, you always have to go with the definition of financial year first. That is section 2 clause 41. Yes, so you can see that here, section 2 clause 41, that decides your duration. Yes, you can see that here, definition of first financial year. But I hope you know that section 2 clause 41. Okay, so tell me, what is the important part in the definition? The date. What is the date given? 1st Jan. I hope you remember that. So 1st Jan. If your company is incorporated before 1st Jan, so in that case, what will be your company's first financial year? From the date of incorporation to 31st of March. But if your company is incorporated on or after 1st Jan, so in that case, from the date of incorporation to 31st March of the next following year. that is going to be the first financial year of your company. So accordingly you will count 9 months. Okay, fine. Yes. So this was about the first AGM, but you know AGM is conducted every year. So what about the second AGM, third AGM, subsequent AGM, right? So for second, third, subsequent AGM, every year AGM must be conducted within 6 months from the end of every financial year. Okay, first AGM within 9 months from the end of first financial year. Subsequent AGM within 6 months from the end of every financial year. Okay, so what if company ask you, come on, tell me what is the due date of holding AGM? What will be your answer? Come on, companies want to conduct AGM, so they are asking you the due date. What is the last date to hold AGM? What will be your answer? No, it is not first AGM. It is subsequent AGM. So company is asking you what is the due date of holding AGM. So you will say 6 months from the end of 31st March. Yes or no? No, that is not your answer. I asked you the due date. What is the due date? You know that? Due date of holding AGM, if you have not mentioned this anywhere, note it down. The due date of holding AGM, because in company law, you will face case study questions. So in that they will, obviously you have to write the provisions, but while writing the conclusion, you have to calculate the date, for example. So you should know how to calculate the due date of holding AGM. So you know what, for due date, due date of AGM shall be what? You need to conduct AGM within 6 months from the end of financial year, right? But so after 31st March you will just calculate 6 months and give the date? No. You know there is one more requirement. You also have to see the gap between two AGM shall not exceed 15 months. Means you need to, before giving answer for due date, you need to consider both the things. Okay, so after 31st March you have to see the 6 months time, whatever the date it is. And after that you also have to see the gap between two AGM, means from the last AGM you have to count the gap of 15 months. So whichever date you get, on whichever day 15 months time is getting expired, so that date and expiry of 6 months, that is here expiry of 15 months from previous AGM. Okay, so 6 months or gap of 15 months, whichever is earlier will be your due date to hold AGM, because when you calculate the due date, both the conditions should get satisfied. Okay, so please make a note of this. Fine, let's go further now. So this was about the first AGM, subsequent AGM, gap between two AGM. Okay, but here you can see there is some additional requirements for listed companies, right? Means we are talking about SEBI LODR. Yes, so generally we saw what was the time limit to hold AGM, but here SEBI LODR is talking about top 100 listed companies. Top 100 listed companies shall hold their AGM within a period of 5 months from the end of every financial year. Generally what it is 6 months from the end of every financial year, but for top 100 listed companies it is 5 months. Okay, and it is not for all listed companies, it is only for the top 100 listed companies, right? Fine, one more thing, top 100 listed entities also have to provide one-way live telecast of the proceedings of AGM. Are you getting the point? Yes, one-way live telecast. You understand this? Everybody can watch the meeting live. Again, this is not for all listed companies, it is only for top 100 listed companies. Okay, now you can see what's next. You can see this is omitted by SEBI LODR regulations with effect from 31st of December 2024. Okay, means now you need to keep a note only of this. Okay, and this one is omitted, one-way live telecast. Now, what about one-person company? Come on, when will one-person company conduct AGM? Not required because there is only one member. So a lone member cannot conduct any AGM. So therefore one person company is not required to hold any AGM. Very simple. Right? Easy? Okay. Next is the gap which we spoke about. The gap between two AGM shall not exceed 15 months, right? But due to some reason, if we want extension of that gap, can we apply for extension of gap? Yes. Is it for all the companies? No. It is for the companies to whom ROC has given the approval. So company may apply for extension of gap to ROC, and ROC may allow you for the extension, right? So friends, extension is allowed. Yes, registrar may allow the extension, but not exceeding 3 months. So maximum extension you can get is 3 months time. Okay, but you know one very important line, you can get extension with the approval of ROC maximum 3 months. Okay, but you know that requirement to hold first AGM. First AGM shall be conducted within 9 months from the end of first financial year. So suppose if you cannot hold the AGM within 9 months, in such case, can you apply for extension of 3 months? Answer is no. So no extension of time can be granted by ROC for holding first AGM. That means that extension was only and only for subsequent meetings. Easy? Okay. Now see this, test your knowledge. It is saying that the gap between two AGM shall not exceed 15 months. Comment. What do you think? Statement is true or false? The gap between two AGM shall not exceed 15 months. True or false? What do you think? Come on, answer me. Come on, online students, what do you think? What is the answer? Come on, everyone, what is the answer? The gap between two AGM shall not exceed 15 months. Yes, so statement is true or false? False, because there are exceptions. What are the exceptions? That you can apply to ROC and ROC may grant you extension of maximum 3 months. Okay, so accordingly you have to draft the answer. This can be in the form of indirect question, and they have asked you to comment on it. Easy, friends? Very easy. You know what? All chapters are very easy. Problem is we are not managing the time, we are not revising it properly. There is no such out of the box complicated concepts. Yeah, it will be complicated if you have not attended the class and everything. Right? So please revise nicely, finish it off on daily basis, right? Chalo, what's next? Next is about day of meeting, time of meeting, place of meeting. Which meeting? AGM. Okay, come on. Now, first thing is, what is the time of holding AGM? So AGM only during business hours. Very simple. And business hours means 9 a.m. to 6 p.m. Anytime between 9 a.m. to 6 p.m. Tell me one more thing. What about board meeting? What is the time to hold board meeting? Anytime. You can hold board meeting other than business hours also? Yes. Because there were no restrictions in holding board meeting. But AGM, yes, only during business hours. Okay. Which day? For AGM, which day? Any day which is not a national holiday. Any day which is not a national holiday, right? What about board meeting? So board meeting can be held on national holiday? Yes. But adjourned board meeting cannot be held on national holiday. Okay, superb. Now, so this was about the time and day. Now place. Come on, where can we hold AGM? So AGM can be held either at the registered office of company or at any other place within the same city, town, village where the registered office of company is situated. Very simple. It's what? At the registered office or any other place within the same city, town, village where the registered office of company is situated. Very simple, right? Okay, now here you can see the meaning of national holiday and all, right? Now, you know the AGM of public unlisted company. So generally the rule says that for holding the AGM, what is the place? Registered office or any place within the same city, town, village, right? But for unlisted public company, you can hold AGM at any place in India. Means even if you don't follow these above rules, registered office, any same city, town, village, it's okay. But for that, you can hold AGM of public unlisted company at any place in India, but with the consent of all the members of company. You need to take the consent of all the members of company. Easy, everybody? Yes. Next is in case of government company. Okay, what is government company? You all know that. So for government company, what is the requirement for place? So it is same as above, but there is one additional line. Okay, so AGM of government company shall be held at the registered office of company or any other place within the same city, town, village where the registered office of company is situated. This is same as above. Or any other place with the approval of central government. This was the additional line, otherwise it is same. Okay, easy, everybody? Yes. Now what about section 8 company? You know, this company always comes with so many relaxation. So for section 8 company, all the rules about time of AGM, date of AGM, place of AGM, everything will be as decided by board. Okay, as decided by the board of directors. Easy, everyone? Any doubt in this? Okay, so this was about day, time and place, right? What is next? Come on, in AGM, we are talking about AGM. What can be transacted in AGM? Can we discuss all the business? No, there are two types of business, you know. One is ordinary business, second is special business. Ordinary business means four things, right? What are those four things? Appointment of director, appointment of auditor and their remuneration, then declaration of dividend and adoption of financial statements. So these are the four things which can be called as ordinary business of company. And in AGM, only and only ordinary business can be transacted. Okay. So, but you must have seen in Companies Act 2013 in your subject company law, setting up of business, wherever we talk about members resolution, ordinary resolution, special resolution. So there are so many different provisions where you need to take the approval of shareholders, right? So when, in which meeting will those resolutions be passed? In AGM or EGM? So obviously in EGM, because in AGM you can discuss only four things, but what we are talking about is other than AGM. So many places, so many provisions you have seen that you need to pass OR, SR, right? So all the businesses which are other than this four are called as special business, right? So special businesses are transacted in another type of general meeting called as EGM, that is extraordinary general meeting, because in AGM only four things, right? Fine. So here you can see the list again, the four things: ordinary business, rest all are called as special business. The meaning of that is given here, special business. Yes. Now whatever rules you have studied about holding AGM, if there is a default in holding the AGM, what is the penalty? So here you can see, if any default is made in complying with the requirements of the meetings of company, in such case penalty will be imposed on company as well as officer in default. Company as well as officer in default. You know, yesterday we revised KMP chapter, in that you saw the definition of officer in default, right? So the penalty will be imposed on the company as well as officer in default. What is the penalty? Penalty is fine of rupees 1 lakh, which may extend to 1 lakh rupees. Okay, if still the default continues, in that case there will be further fine of 5,000 per day till such default continues. Are you getting the point what I'm saying? Easy, everybody? Yes. So if there is any default made, company as well as officer in default, yes, fine of rupees 1 lakh, and if the default continues, then it is 5,000 per day till the default continues. Easy? Fine. Now what is next? Next is, yeah, then you can see if the default is made in holding the meeting. You can ask the tribunal, and tribunal will direct the company to conduct AGM. Fine. So this was about AGM. Now next topic what you can see is conveying a valid general meeting. When can you say a general meeting is validly conducted? When can you say that? What are the requirements for that? What are the essentials for that? So there are three things. First, meeting must be properly convened. Second, meeting must be properly constituted. And third, meeting must be properly conducted. Okay? That means what? See, first thing is, meeting must be called by proper authority. You know, everybody cannot call a meeting. So meeting must be called by proper authority. For calling a meeting, you all know that we need to send a notice. So proper notice must be given, right? And when we talk about notice of general meeting, then we remember always section 101 and 102. So proper notice must be given to call a meeting. So proper authority, proper notice. Then properly constituted means what? Means the required number of people, members should be present in the meeting. That means we are talking about quorum. Proper quorum must be present, and also chairman must be present. Okay, only then you can say meeting is properly constituted. And properly conducted means what? You know, we are conducting the meeting of members to pass the members resolution. So for members resolution it can be OR or SR, right? But for OR or SR you need to take the voting of members. So for OR there is a rule that OR means majority votes, SR means votes in favor must be 3 times the votes against. So resolution must be properly passed. Okay, means proper type of voting as per the rules shall be conducted. And lastly, you need to maintain proper minutes. Proper minutes must be maintained. Only then meeting is validly conducted. Okay, so these are 3 essentials, very simple, right? Easy now everyone? Okay, so we are moving to the next section, that is now section number 100. Yes, so in the previous thing we saw AGM, now we are going to see EGM, extraordinary general meeting. What is this extraordinary general meeting? So see, for AGM there is a rule that you need to conduct AGM only once in a year, correct? But for EGM there is no such rule. So EGM means any general meeting which is not an AGM means it is EGM. Any general meeting which is not AGM is EGM. I hope this is clear. All general meetings other than AGM are called as EGM. Okay, why EGM is conducted? Obviously to pass members' approval. But sir, that can be done in AGM also. No, in AGM there is a limitation. You can discuss only ordinary business, but other than that, if you want to discuss any special business, you can do that in EGM. Okay, so if there are no rules for holding EGM, when EGM shall be conducted, who can call EGM? So EGM can be called by any of them. Come on, first one is by board of directors. Second, by board of directors on requisition of members. Then by requisitionists themselves, and fourth is by tribunal. Easy. So any of them can call EGM. Let's go with it. So you can see the first one. What is that? By board. Suo motu. Means the board of directors can call EGM. Okay? When? As they deem fit. Board may call it as may deem fit. Means to take the members' approval, right? That is for passing ORSR for any special business, board can call EGM anytime. Okay, now tell me one thing, what is the rule for holding EGM? Like for AGM we saw the places. It should be at the registered office only, here only, within same city, town, village. What is the place for EGM? So answer is EGM can be held at any place in India. Okay, so it is any place in India. But if our company is a wholly owned subsidiary company of a company which is incorporated outside India. Come on, once again, if our company is a wholly owned subsidiary company of a foreign company. So if we are conducting EGM for this our company, so can I say our 100% shares are with a foreign company? Yes. So EGM of this company can be held outside India also. Otherwise it should be held in India only. Okay, so here it is. EGM, which is wholly owned subsidiary of a company incorporated outside India, can be held outside India. Otherwise it is any place in India. Easy? So first point is done, that is EGM can be called by board. When? As board deems fit. Okay? Yes. Next is, again it is by board, but this time by board on requisition of members. That is on request of members. Come on, can members request the board to call EGM? Yes. So if today I am a member of Reliance Industries Limited, can I go and request the company, come on, call EGM, can I alone go and request? No. So you need a certain number of members. So who can make this type of request? So answer is, first, who can make a request? So first, if company is having share capital, if company is a type of company which is having share capital, in such case request shall be made by members whose holding is not less than 1/10 of the total paid up share capital of the company. Are you getting it? By the members whose holding is not less than 1/10 of the total paid up share capital of the company. Okay. And next one you can see is, what if company is not having share capital? If company is not having share capital, means there will be no paid up share capital. Correct? So in that case, who can make the request? Members having not less than 1/10 of the total voting power. So they can make a request. Now if these people are making a request, come on, the board will now conduct a meeting? Yes. Within how much time? Board shall proceed to call the meeting within 21 days and conduct the meeting within 45 days from the date of request made. Correct? So board shall proceed to call the meeting. Board proceed to call a meeting within 21 days and meeting should be held within 45 days from the request made. So can I say this 45 is already including that 21 days? Yes. Everybody clear? Easy? Fine. So now these people can make a request in this way. Okay. Whenever they are making a request, they have to make a request in writing, and request must be signed by all the requisitionists and sent to the registered office of company. Okay. Easy? Yes. Next is by requisitionists themselves. Now just now we told that the members will make a request to the board. Now then board will call a meeting. Board will conduct the meeting within 45 days, right? But what if board fails to conduct the meeting within 45 days? What if board does not call the meeting within, announce the meeting within 21 days and fails to conduct a meeting within 45 days? Now what to do? We made a request, but board did not conduct the meeting. So in that case, requisitionists themselves will call the meeting. Meeting may be called by requisitionists themselves. They themselves will conduct the meeting. And such meeting, which they are conducting themselves, must be conducted within a period of 3 months from the date of request made. Means this 3 months will include everything. 45 days, 21 days, everything. Okay, easy? Yes. Then, if you talk about this request for calling EGM by members, I already told you it shall be made in writing, signed, electronic, means and all those things. Okay, whenever they are conducting the meeting themselves, obviously they will incur some expense. So who will pay those expenses? Company will pay the expenses, right? All the reasonable expenses incurred by the requisitionist, the amount shall be reimbursed by the company. Company will reimburse the money. Clear, everybody? Yes? Any doubt in this? Okay, done. So this was about it. Okay, one more thing. You know, if whenever the quorum is not present, meeting is adjourned, right? But you know what? If the meeting is conducted by requisitioners themselves, and in such meeting if quorum is not present within half an hour, in that case meeting shall not be adjourned, meeting shall be directly cancelled. Are you getting it? Generally when the quorum is not present, meeting is adjourned. But if the meeting is called by requisitioners themselves, it shall directly get cancelled. Okay, next is this. Can you see this? These are the rules of making a request. Have you read this anytime? Everyone? It's very simple. See, I already told you about this. Whenever you are making a request, it shall be signed by all the requisitionists. Okay? Then no explanatory statement need to be annexed to the notice of EGM which is called by requisitionists themselves. You know what? Generally when we send the notice, we need to attach explanatory statement. In the board meeting we discussed about notes on agenda. Similarly here you need to attach explanatory statement, which we will be doing in section 102. Okay, so you need to attach that. What is explanatory statement? Details of topics to be discussed, right? So that is to be attached generally. But if the EGM is conducted by requisitionists themselves, no need to attach explanatory statement along with the notice of such meeting. Easy, everyone? Yes. Now, can you see this? What they are saying? The notice. When this notice shall be given? No. Okay, fine. You will read that. Okay, so you buy this following this new module. Okay, so when they are saying this, see, the notice of meeting shall be given to whom? To whom? So it shall be given to the members whose name is there in ROM. Okay, that is within 3 days. Within 3 days on which the requisitionist make a request with the company. Okay, so that way it is. Then mode of sending the notice, electronic means and all. You can read these simple things, right? So this was third part is requisitionist themselves. Now fourth one is by tribunal. So now here, you know, tribunal NCLT is the authority. So obviously tribunal may suo motu, that is on its own, or on application made by director or members may call EGM as it thinks fit. As it thinks fit. Firstly, I have a doubt why members are going to tribunal. You know, members can make a request to board also. If members make request to board, then board will conduct the meeting. Yes or no? So why members are making application to tribunal? That is one of the circumstances. I mean to say is why members are requesting tribunal to call EGM. Members can make application to board, then board will call EGM. We did that in the second point. Correct? So answer is, for making an application to board, you need a certain number of members. How many members are required? Members holding 1/10 of the total paid up share capital, or members having 1/10 of total voting rights. Correct? So what if the people who are making the request to board are not having certain holdings? So in that case they can request to tribunal. Okay, so that can be the circumstances. So after this 4 things, next part you can see is class meeting. Okay, this is a similar concept. You know what is a class meeting? Class meeting means it is a meeting of a particular class of security holders. It is a meeting of a particular category of security holders, particular category of shareholders. Like for example, if company is calling a meeting of debenture holders, so can all the shareholders come? No, only debenture holders can come. If there is a meeting of only preference shareholders, can equity shareholder come? No. So can you see it's a meeting of a particular category of investors. Okay, that meeting is called as class meeting. Very simple. So generally, You can see here members meeting is divided into two categories. General meeting, class meeting. What is class meeting? Class meeting are the meeting of shareholders holding a particular class of shares. That is particular category of shares. Now whatever resolutions are passed in such meeting, that resolution will bind only the members of that particular class only and no other members, correct? Okay, who can attend the meeting? Only that particular class may attend the meeting, vote at the meeting. Okay, all other rules for holding a general meeting shall be same applicable on class meeting also. Okay, you can see here all the rules related to voting, this, that, everything is same as general meeting. Now what are the circumstances when the class meetings are conducted? So here you can see they have given three examples. One is section 48. Do you remember that? What is 48? Variation in shareholders' rights, which you do that in your chapter members and shareholders. Then second example is you can see 232 merger and amalgamation chapter, right? In that case they need to take the consent of debenture holders and creditors. So in that case they will call the meeting of only debenture holders, right? And then also you can see in section 92. So all these are the circumstances, right? Otherwise your class meeting is from year to year. Okay, yes, you can see this again, meeting of debenture holders, again a particular category of security holders. Then we are coming to adjourned meeting. Come on, what is adjourned meeting? So firstly, quorum is required in the meeting. If quorum is not present within how much time? We are going to wait for half an hour. So if the quorum is not present within half an hour from the scheduled meeting time, so in such case meeting shall stand adjourned. Adjourn means what? Cancel. Meeting shall be adjourned to same day, same time, same place, next week. Understood? Same day, same time, same place, next week. Okay, now here you can see or any other day as decided by board. So if quorum is not present, meeting is adjourned. Now friends, what is adjourned meeting? So firstly, adjourned meeting is not a new meeting, it is continuation of original meeting, correct? What can be discussed in adjourned meeting? Only the unfinished business items of the original meeting can be completed here, right? Nothing other than that. One more thing friends, if the meeting is adjourned, do we need to send a notice of adjourned meeting also? Are you sure? What about in board meeting? If board meeting is adjourned, we need to send the notice of board meeting also, adjourned board meeting also? Yes. How many days prior notice? 7 days. But in case of general meeting? So first you need to check whether the meeting is adjourned for less than 30 days or 30 or more days. It is not 3 months, it is 30 days. So if it is adjourned for less than 30 days, in that case you need to send the notice of adjourned meeting how many days prior? 3 days before the meeting, at least 3 days before the meeting. And if the meeting is adjourned for 30 or more days, 30 or more, then you need to give entire 21 clear days notice. Correct? So that was about notice of adjourned meeting. And one more thing, wherever it is not practical to send the notice, company can also give notice either individually to all the members, or company can also publish the notice in the form of advertisement in 2 newspapers, one in English and one in vernacular language. Easy? Okay, fine. Now quorum was not present, we waited for half an hour, quorum is not present and meeting is adjourned. Now in the adjourned meeting also quorum is not present. Quorum is not present in adjourned meeting also. Now what to do? We adjourn the meeting because quorum is not there. Now in adjourned meeting also quorum is not present. Now what to do? What if I ask this question in board meeting? If I ask the same question in case of board meeting, that quorum is not present in adjourned meeting. So in that case what will happen? Meeting shall stand cancelled. But we are discussing right now general meeting. So in that case, if In adjourned meeting also, quorum is not present within half an hour. In such case, here meeting will not get cancelled. Here, the number of members present, not less than 2, shall form the quorum. Shall form the quorum. Easy, everyone? Any doubt in this? Everybody sure? Okay, fine. Next. So here you can see the procedure for holding adjourned meeting. Yes, I already told you about this, right? You need to give notice and all, right? Now tell me one thing. Can chairman adjourn the meeting? Yes, chairman is the person who makes the announcement for adjournment of meeting. Can chairman adjourn the meeting when the quorum is present? When quorum is present? Yes. He can adjourn the meeting when the quorum is not present? Yes. Then obviously will adjourn. But he can adjourn the meeting even when the quorum is present? Yes. He can do that. But for that he needs to take the consent of the members of company. Okay. So with the consent of members, he can adjourn the meeting at which the quorum is present. Is this clear to everybody? Okay. But as I told you, here meeting is adjourned for the want of quorum. Right? Chairman can adjourn the meeting, I told you. We spoke about 30 or more days. If the meeting is adjourned for 30 or more days, so what will happen? Notice shall be given in accordance with the provision of this act. That means entire 21 days notice. If meeting is adjourned for less than 30 days, so already we have discussed this. In that case, company will give the notice of 3 days. At least 3 days notice shall be given, or by publish an advertisement in the 2 newspapers, English and vernacular. Easy, everybody? Okay, we already spoke about this thing also. I told you, right, if the meeting is called by requisitionists themselves and quorum is not present, the meeting shall be adjourned? No, meeting shall be directly cancelled. Okay, easy. Now friends, we already spoke about this. What are adjourned meetings? So adjourned meeting is not a new meeting, it is continuation of the original meeting, right? Now tell me one thing, what if a resolution is passed on the adjourned meeting? If a resolution is passed at the adjourned meeting, tell me what will be the date of such resolution? The date of original meeting or the date of adjourned meeting? Come on, you understood my question? A resolution was passed in the adjourned meeting, and as we have discussed, adjourned meeting is not a new meeting, it is continuation of the original meeting, right? So tell me in this case what will happen? What shall be the date of what shall be the date of resolution? The date of original meeting or date of adjourned meeting? So answer is that resolution shall be dated as on the date of adjourned meeting and not the original meeting. Because resolution is always dated on the day on which it is passed. Okay, so here you can see only unfinished business shall be transacted at adjourned meeting. Any resolution passed at adjourned meeting shall be deemed to have been passed on the day of adjourned meeting and not on the earlier date. Easy? Everybody clear? Fine. So then we are moving to types of resolutions. Yes, you know very well when we are talking about members resolution, so there can be OR, SR. These are the 2 main resolutions, and then you have resolution which requires special notice. Right? So you know, I hope everybody knows what is OR. Very common thing. There are many provisions where you need to take the approval of members by passing OR, and there are many provisions where you need to take the approval of members by passing SR. Correct? So what is OR? OR means you can pass this just by majority votes. And SR, you know, votes in favor must be 3 times the votes against. This is a simple majority, this is special majority. So that is the difference. This we are going to do further. Okay, so here is the explanation of OR, SR, right? We have discussed this many times. Here we are coming to this part now. Resolution requiring special notice, that is this one, the last one. Okay, fine. Now what is this? Resolution requiring special notice, section 115, what it is? So friends, you know, generally when company sends a notice of general meeting, So what do you think? Every member will go and attend the meeting? Every member goes and attend the meeting? No. You know, people just ignore the notice. People ignore the meetings also. But you know what? The main thing is, what about their voting rights? They have voting rights, they have decision making power, but people don't really go. But you know, there are few matters which are very important, right? So for those matters, law says that we don't just have to give the notice of meeting, but we need to give special notice. What is that special notice? Special notice is given to show the importance of that agenda, right? So in different sections you must have heard this. Example is section number 169, removal of director. Do you remember that? Removal of director. So here you can see there are 2 points, A and B. In my notes I wrote this in the 4 points, 1, 2, 3, 4, if you remember. So first one was removal of director. Means if company is conducting a general meeting to remove a director, come on, tell me everyone, director can be removed by whom? Who can remove a director? Shareholders, members of company, by passing which resolution? OR or SR? OR. Understood everyone? Company can remove a director by passing ordinary resolution in general meeting, right? So now to pass that OR, you want to invite members, they will come, they will vote, right? But removing a director is a very important decision. Therefore, for such general meeting, company will not just send a notice, but company will send special notice. That is to show the importance of that agenda. Why company is doing this? That is because company wants maximum participation, right? So that is the point. So for removal of director, and also if company is going to appoint a new director in place of removed director. If company is going to appoint a new director in place of the removed director in the same meeting. So again that meeting is very important now. So again company will send special notice. So removal of director, okay, then appointing someone in place of the removed director. Same for auditor also, appointing the new one, removing the current one. So this 4 things, for this 4 agenda, company don't just send notice of general meeting, company will send special notice for this 4 thing, okay? But what if, see, can you see this? This matters in respect of which special notice are required to be given, okay? Now what if, friends, members of company wants the company to send special notice for other agendas also? Obviously these 4 things are important, understood, but the members of company wants the company to send special notice for other things also, other agenda also. So the point is, can members of company request the company to send special notice, that is to show the importance of other agenda also? Yes. So how many members can make the request? So answer is members can make a request, but such number of members shall be the members holding not less than 1% of total voting rights, or the members holding shares not exceeding 5 lakh rupees of the total paid up share capital. Understood? So how many members can make a request? Members whose holding, number of members whose holding not less than 1% of total voting rights, or the members whose holding is aggregate 5 lakh rupees of the total paid up share capital of the company. So this many members can request the company, and then company will what company will do? Company will send special notice for other agendas also to all the members. Okay, now see this procedure. Firstly, tell me who is requesting the company? Members are requesting the company. For what? For sending special notice, right? So now here are the 4 points, here are the rules. When can members make this request? When can members make this request? Let's see. First, whenever they are making a request to the company, that request shall be signed either individually or collectively by the members whose holding not less than 1% of total voting power, or holding aggregate of 5 lakh rupees. So basically people who are making the request shall sign the request. Second, can you see the sending of notice to the company? What is the sending of notice? This is sending off that request notice. This is request notice. Write it down if you want. Because see what is written, sending off notice to the company. So we are requesting to the company. So that request must be firstly signed. Second, such notice shall be sent by the members to the company when? So answer is at least 14 days before the date of meeting. Sir, at least 14 days before the meeting. At least 14 days. We will make request to the company 6 months before the meeting. You can't do that because it is at least 14 days before the date of meeting, but not earlier than 3 months. So at least 14 days before, but not earlier than 3 months. You understood? Means this request can be made to the company, that is 14 days before the meeting, but not before 3 months. Clear? So this is again the request what members are making to the company. Next is, once the company receives that request, what will company do? Company will send special notice, right? So company shall immediately give its members a notice of resolution at least 7 days before the meeting, and the 7 days will be 7 clear days. You are going to exclude the date of meeting also and date of notice also. Easy, everyone? Yes, and if it is not possible for the company, it is not practicable to give the notice, send the notice, so company can also publish the notice in the newspaper, English as well as vernacular newspaper. When to publish this in the newspaper? Again same. You understood? Members are making request to the company, and then company will send special notice to all the members as per the request. But when will company send that special notice? 7 days. That is at least 7 days before the meeting. Same as this. Here also it was 7 days only. Easy? So what do you think? Module is easy? So why you people don't read module? Yes? So you people have finished reading your module? Online YouTube students? Yesterday we revised 2 chapters. Have you finished your module of board meeting and KMP? All the students who attended yesterday's revision class, you have finished reading module? One time. Sorry? Please be loud. Please, one more time. No, what you told? Which chapters? So everyone, he has finished reading module of which chapters? Let me see. Which chapters? Which chapters? One more time. Important chapters. Okay, how you know which chapters are important? Tell me which chapters are important. According to your expert opinion, all chapters are important. Important chapters. In CS executive, everything is important. If you skip chapters, you are gone. Okay, I told this yesterday also, right? There is nothing like important chapters. Each and every line is important. Okay? That is the reason results are so less. Because students don't read everything. Right? It's not a graduation exam, no? They can ask anything from anywhere. Okay? See that? What Gayatri is saying, every chapter is important. ये तेरे से अगेंस्ट नहीं है, हम सब तेरे से अगेंस्ट है, because you are talking about important chapters. All chapters are important. क्या कर रहा है? ये मेरे अगेंस्ट है. क्या यार? Okay, you know we are done with almost like half of the chapter. जब तक ना आए, बराबर है ना यार? आप एक ही बार पढ़ो, एकदम अच्छे से पढ़ो, हो गया, सब कॉन्सेप्ट्स याद है, आपको समझ के लेना. यू कैन रेक्टिफाई दिस 980 पेजेस, नो? समझ के लो ना भाई, जनरल मीटिंग नोटिस ओके ऐसे भेजना, कैसे ऐसे ऐसे भेजना, ऐसा भेजना नॉट अलाउड, ऐसा भेजना अलाउड, ऐसे समझ के करो. फिर आपके सामने तो केस स्टडी क्वेश्चंस आएंगे, situations will be given, so accordingly you can answer. So understand it, don't try to rectify all this, it is not possible. Fine, 1 minute relax, like yesterday. You can eat again whatever you want to eat. चलो लेट्स कंटिन्यू नाउ. नेक्स्ट क्या है? नेक्स्ट टॉपिक इन दिस मॉड्यूल इज process of passing a resolution. Very simple thing, whenever we pass a resolution in a meeting, first thing is a draft is kept in front of the members. That draft is called as motion. Motion means proposal, right? And then voting is conducted. If the required votes are achieved, then that motion becomes resolution, right? So that is the meaning of motion, resolution, right? Chairman, right? So next section is this one, that is 117. 117 is very simple. In which circumstances companies are required to file form MGT14 with ROC. Okay, this section is all about this. Resolutions and agreement to be filed with ROC, inform MGT 14. So in this section, you can see there is a list of circumstances here. These are the list of circumstances where company is required to file the resolution with ROC, inform MGT 14 within 30 days from the date of passing resolution, and then ROC will register the same. Okay, so what you need to do is you just have to go through this list. Okay, you have already done this list individually in different sections as also. Okay, and yes, if company fails to do so, there is a penalty. Very simple. Right, so next conceptual is 101, very important section, notice of general meeting, right? Come on, we already did notice of board meeting yesterday, right? Come on, tell me friends. So always we need to call a notice, we need to send a notice to call general meeting. Notice always must be in writing because oral intimation is not a valid communication. Correct? Now, what shall be the length of notice? We need to send notice of general meeting at least 21 clear days in writing or through electronic mode. At least 21 clear days notice. What is clear days notice? Yes, clear days refers to we need to exclude both the things. Date of notice and also date of meeting, both shall be excluded. But you know, when we talk about board meeting, 7 days before the meeting, in that 7 days date of meeting shall be excluded, but date of notice shall be included. But here both are excluded, therefore here we are not just saying 21 days, we are saying 21 clear days. Okay, and those 21 days must be full days, full calendar days. Easy? So company have to send 21 clear days notice before the meeting. Okay, next is, you know, in case of section 8 company, company is not required to give 21 days notice. Company can give only 14 days clear notice instead of 21 days. Remember this. For section 8 company it is 14 days instead of 21 days. Now you know we did something, if the notice is sent by post, same thing was given in board meeting chapter also. In that case 2 additional days shall be counted. Do you remember that? In board meeting, but here they are calling it as 48 hours addition shall be done for the service of notice. You need to count 2 additional days? No, here they are saying 48 hours. There it was 2 days, here it is 48 hours. So practically it means the same. Yes or no? 48 hours. Good. Because what this person used to do, whenever it is like within 30 days, he used to say within 1 month. Right? He used to convert days into month into days. But wherever the days are given, we will say days. Wherever month is given, we will say months. Because you know, if you write within 1 month instead of 30 days, so you know month can be for 31 days also. Therefore, 21 days का भी हो सकता है. Good. 28 का भी हो सकता है. Good. अच्छा है. Nice information. चलो. So you understood this. If it is sent by post, you need to count 48 hours in addition to 21 days. That is for the service of notice. Okay. Then again same, when it is not practical to send the notice, you can also publish it in the newspaper, one in English and one in vernacular. Easy. Then what is a valid notice? Then, okay, see this. Already we have discussed this in class also. Read the question. ABC Limited issued a notice on 1st August 2020 to hold its AGM on 24th of August. Check the validity of notice referring to the provisions of the relevant act in case it is sent by post. Come on, tell me. Sorry? Why? Yes. How? Everybody understood? See, ABC Limited wants to hold its AGM on 24th August. So the date of meeting is 24th August. Okay. But notice was issued on 1st August. Notice was issued on 1st of August. So now tell me, check the validity of the notice. So friends, you know it's a AGM. So obviously 21 clear days notice must be given, right? So friends, whenever we count 21 clear days notice, we always exclude the date of meeting and date of notice. Okay? So from 1st to 24th, come on, tell me, we are going to exclude both date of meeting, date of notice. So what are the number of days left? 22 days. So company has given 22 days notice. Yes or no? So company has satisfied the requirement? No, because company have sent it by post. If it is by post, 48 hours addition you need to count. That means more 2 days will be deducted. So company has given only 20 days prior notice. And company was required to be sending 21 days clear days prior notice. So has company satisfied the requirement of sending notice 101? No. So now what is the remedy? What is the remedy? What is the solution? Come on. What company can do? Wrong answer. That was wrong. That is wrong answer. You were explaining some other provision. You are explaining me 115. See, company has not satisfied the requirement of 21 clear days notice. No problem. You can advise the company to call AGM at short notice. Yes or no? So for AGM, you can conduct AGM at short notice by with the written consent of 95% of total number of members. Understood? So always you need to give solution to the company. Okay, what are the remedies available? You need to answer that. Okay, so company has not satisfied the requirement here. Fine, let's go further now. See, here is the short notice concept now. So generally it is 21 clear days notice, but yes, company may call meeting at short notice also. Now when we talk about general meeting, we will talk about both, because 101 is talking about notice of general meeting, means it is covering both AGM also and EGM also, right? So here you can see, as per section 101, company may call a general meeting at short notice, but what are the conditions? So first, in case of AGM, consent of not less than 95% of total number of members is required, right? But if it is EGM, then first you need to check whether company is having share capital or company is not having share capital. If company is having share capital, then what to do? Then you need to take the consent of members, yes, having not less than 95% of total paid up share capital of the company. In that you need to see the holding. And if company is not having share capital, in that case you need to take the consent of the members having not less than 95% of total voting rights. Okay, so these are the conditions. Easy everyone. So it's about AGM also and EGM also. In AGM you see the number of members. In EGM you see whether company is having share capital or not. Okay, fine. Now next is again the same. You can see in case of any other general meeting, it is same, not less than 95% of total paid up share capital, or it is not less than 95% of total voting rights. Right, the same thing is given here. Notice shall be given for every meeting. In addition to that, private company, yes, done, nothing new in this. Now next is about contents of notice. Very easy. What are the contents of notice? What all things are mentioned in the notice? So very simple. Here you are going to see one by one, repetition also. The first is place of meeting. Come on. In place of meeting, if we talk about AGM, come on. What shall be the place? We have already done place of AGM earlier in section 96, right? What is the place? Either registered office of company or any other place within the same city, town, village where the registered office of company is situated. Easy? Everyone? Yes. Then, do you remember that? Okay, what about EGM? Any place in India, correct? Then, what about AGM of unlisted public company? We have done this, any place in India, but you need to take the consent of all the members of company, right? Then what about place of AGM in case of government company? So again, registered office of company or such other place within the same city, town, village, okay, or such other place as central government decides. Easy, everybody? Yes? Okay. Now friends, whenever you give the notice of general meeting, okay, you shall also specify the details of venue, obviously. But whenever you mention the details of venue, you shall also include route map of that location. You must have seen in many invitation on the backside, you will see the route map, how to reach there for easy location. But today we have Google Maps. But fine, you need to mention route maps also. Route map and prominent landmark for easy location. But you know, there are exceptions. Now exceptions means in these two cases you don't have to mention route map. So that is in a company which only directors and relatives are members. If there is a general meeting of a company where only directors and relatives are members, that means can I say they all will leave the house together? So they know where the meeting is there, no need to mention route map. And secondly, in case of the meeting of wholly owned subsidiary company. Okay, done. So this was about place. Okay, now it is about the day of meeting. Come on, tell me AGM, what day? AGM shall be conducted on a day other than national holiday. Easy? Here you can see the examples of national holiday. Next is, okay, what about EGM? EGM? Any day, including national holiday. Okay, board meeting? Any day, including national holiday. Adjourned board meeting, not allowed. Come on, time of meeting. First, AGM. Come on. Time. AGM, then it is only during business hours, 9 a.m. to 6 p.m. Right? What about EGM? There are no such restrictions of timings. Clear, everybody? Easy? Fine. Section 8 company. We have already done this. There is no restriction related to day, time and place. Everything shall be as decided by board. Easy? Then notice shall also contain agenda. What is agenda? Business to be transacted at the meeting. Business to be transacted at the meeting. Okay? Then, come on. What if you cannot attend a particular general meeting? Can you appoint a proxy? Yes. Tell me, can you appoint a proxy in board meeting? No. But in general meeting? Yes. You can appoint a proxy in general meeting. So friends, now the point is, if you are a member of company, if you are a shareholder of company, and if you want to send someone, you know there are rules for a proxy. You cannot just send anyone anytime. You need to give prior information to the company that who is going to attend on your behalf. So how will all the shareholders know about the rules? Every shareholder has not studied law, correct? So therefore, we are going to mention the proxy rules in the notice itself, so that they have an idea how to appoint a proxy, when to appoint a proxy. Right? But there is an entire section 105 related to proxy. We are going to revise that also today. Okay, fine. Next is, yes, now you can see there is a procedure to send a notice. So you can just read this procedure today. Now next is what? Yes. Who shall receive the notice? Person entitled to receive the notice. So as we are talking about general meeting, notice of general meeting shall be sent to members of company, directors of company and auditors of company. Correct? This three. So friends, you can see every member of company, auditor of company, director of company, right? Yes. And what if the member of company has died? So in that case, nominee. If nominee is not appointed, then legal representative of deceased member. If member is insolvent, then assignee of that member. Easy? So this is about sending the notice, to whom notice shall be sent. Okay? Friends, what if company fails to send a notice to one of the members of company? What if company fails to send a notice of general meeting to one of the members of company accidentally? In general meeting, what is the rule? If company fails to give notice to one of the members, in such case, so if you don't send the notice to one of the members, this is not going to affect the validation of that meeting. Right? That means that meeting shall remain valid. Resolutions passed in that meeting shall remain operative. Clear, everybody? Yes. But if this question was asked in board meeting, if you fail to send notice to one of the directors, such board meeting shall be invalid and resolutions passed shall be inoperative. Is this clear to everybody? Yes. Fine. Can you see this point here? Non-receipt of notice, accidental omission to give notice to any of the members shall not invalidate the proceedings of the meeting. Okay, is this clear to everybody? Now next is what? Yes, again you have a list. Notices shall be sent to whom? Directors, auditors and all, and here is the list of that. So we will send it to members of company, directors of company, auditors of company, okay? But there can be a situation where member died and company has received the intimation of his death. Means company has received the intimation, company is having knowledge of the death of the member. Now what to do? So notice shall be sent to whom? So if nominee is appointed, then it shall be sent to the nominee. Okay? What if the shares are held by more than one person jointly? Means it is a case of joint shareholding. So if there is a joint shareholders, there are two shareholders A and B jointly holding the shares, and if one of the owner dies, so in that case notice shall be sent to whom? Nominee? No, it shall be sent to the other surviving member. If one of the member dies, it shall be sent to the other surviving joint first holder. But what if there are shareholding jointly held and both the joint holder dies? Then nominee. If nominee is not appointed, in that case legal representative of deceased member. If member has become insolvent, it shall be sent to the assignee. If a company, if a member of our company is a company, if a company or a body corporate is member of our company, if a company or a body corporate is a shareholder of our company, and now we are conducting a general meeting, in that case we will send notice to all the members, including the companies who are the members of our company. So in that case we will send notice to the company, and okay, here they are talking about companies being wound up. Company is going to winding up. In that case notice shall be sent to the liquidator. So here is the list, notice shall be sent to whom. Okay, and again you can see the list here. Okay, yes. So now we have reached to section number 102. What is 102? Explanatory statement. Do you know what is explanatory statement? Similar thing we did in your board meeting, but the heading was notes on agenda. That is details of topics to be discussed. And here the same thing is called as explanatory statement. So I did this topic in class in 7 points covering everything what is given here. So are you ready? Chalo. First thing, it is section 102. Okay, and it is called explanatory statement. What it is? So whenever we send the notice of general meeting, we always mention agenda in it. But agenda can be just headings, titles, or it is very much in summarized way. Now if the agenda is sent to all the members, how will member will decide their vote? They don't know the details of topics to be discussed. They don't know the details of transactions which are going to happen. So how will they decide their vote? Therefore company, along with the notice, company will attach explanatory statement. So what it is basically details of topics to be transacted at the meeting. It is details of topics to be discussed, one thing. Second thing, this shall also contain the interested parties. Means whatever topics which are going to be transacted in the meeting, if any of our director, KMP, manager, other officer, promoter is a interested party in that business, so in that explanatory statement we are also going to mention his interest. So director, KMP, manager, promoter also have to disclose his interest in that explanatory statement. So that when the members will come to vote, they are very much clear that if this resolution is passed, this so and so person may get some benefit. So interest must be disclosed in the explanatory statement. It is containing all the material facts, details of all the transactions which are to be done in the meeting. Correct? Then this must be drafted in a manner which enables the member to understand the implication of the agenda topics. That means if the resolution is passed in the meeting, what will be the consequences? What shall be the effect of that? Everything should be clearly understood and mentioned in the explanatory statement. Right? What's next? You know that topic about disclosure of interest which I told you, that was originally done in section 184. But you know, in that section 184, I also told you that if the shareholding is up to, if the person is having interest in the opposite company, but if the person is having the shareholding up to 2% of the paid up share capital of that company, up to this much, then section 184 is not applicable. So same way here also, if our director, KMP, manager is an interested party, but if he is having interest within the limit, so in that case explanatory statement will not contain the interest of such directors, KMPs and managers. Do you remember all this? Okay, tell me one more thing. Do we have to attach explanatory statement for along with the notice of every general meeting? Do we need to attach the explanatory statement along with the notice of every general meeting? No. We need to attach explanatory statement along with the notice of EGM. That is where we discuss special business. Right? So in that case, you need to attach explanatory statement. Then, last 2 points. First, 1 point. If in the upcoming general meeting, we are going to take a decision giving reference to any of the document, report or any other statement, statistics, quotation, right? Means in the upcoming general meeting we are going to take a decision which is based on a report. We are going to give reference to a report, to a document. Now if you are calling members of company to please come and vote for a particular resolution, but you are going to decide that giving reference to a document. Now how will the members of company know about the document? They have not seen the document, so they need to go through it to decide their vote. So what you need to do, whenever you are giving notice of general meeting, Along with the notice, you will attach explanatory statement. In that also, you are going to attach what? Explanatory statement you are going to write in that, that the time, date and place where members can go and inspect the document before attending the meeting. Because we are going to give reference to a document. So specify the time, date and place where members can go and inspect that document. No. Here they are saying that you have to mention the date, time and place. You want to attach, you can attach. There is no restriction. Therefore it is allowed. Okay. But you can mention the address, date, time and place where they can go and inspect. So member will inspect the document, then they will be present in the meeting. So the decision will be very quality decision. Okay, easy. And one last point covering this is, what if the director, KMP, promoter has not disclosed their interest? If the director, promoter, KMP have not given disclosure, or they have given insufficient disclosure of their interest in the explanatory statement. Now meeting was held, resolution was passed, and some benefit was given to them. They have received some advantage by non-disclosure of their interest. So what will be the consequences of that? Consequences is they have to return that benefit to the company, and it shall be treated as if that people are holding the benefit in the trust of company. Plus, they are also liable to compensate the company for the damages if there is any damage to the company. So this is the effect of non-disclosure of interest or insufficient disclosure of interest, right? So all these things you can see here. So can you see this? We did just now, effect of non-disclosure, and lastly we have penalty also. Okay, easy everyone? Yes, so if any default is made in complying with the provision of 102, so in that case every promoter, director, manager, KMP who is in default shall be liable for a penalty of 50,000 rupees or 5 times the amount of benefit received, whichever is higher. Okay, very easy. Yes. Okay, you remember that line when we discussed that about EGM? I told you if the meeting is called by requisitionists themselves. So for such meeting, see this explanatory statement need not be attached with the notice of EGM, which is called by requisitionists themselves. Okay, so we're done with this also. 101 is done, 102 is done. Now we are moving towards 103, that is quorum. Okay, yes, so 1 minute break before going towards quorum. Just relax for 1 minute, then we will continue. And we will go for your actual break after we finish the chapter. Okay. Chalo, quorum 103. Quorum. Yes. What is quorum? You all know that yesterday we have done that in board meeting also. So quorum means minimum number of. In board meeting chapter we did minimum number of directors. Here we need minimum number of members required to constitute a valid meeting. You know, in board meeting chapter, quorum was very fixed. It was very clear. 1/3 of total number of directors or 2 directors, whichever is higher. But here, in general meeting, what shall be the quorum of general meeting? That depends on the number of members of company. See, there are two categories here. You can see one is public company, second is private company. Okay, in public company, what shall be the quorum for general meeting? So first is you need to check the number of members in your company. If the total number of members in your company are not more than 1000, so quorum shall be 5 members must be personally present. You know what is personally present? Proxies are anyways not counted in quorum. They have to attend the meeting in physically. So 5 members must be personally present. Okay. If the number of members are not more than 1000, means can I say up to 1000? Yes. If the number of members are more than 1000 but up to 5000, more than 1000 but up to 5000, in such case quorum is 15 members must be personally present. But if the number of members are more than 5000, then 30 members must be personally present. 5, 15, 30. This is in case of public company. Okay, easy. 5, 15, 30. But if we talk about private company, only 2 members are required to be personally present to satisfy the quorum requirement. Okay, very simple. Okay, here also, you know, just like board meeting, what is the quorum of general meeting? So quorum of general meeting shall be as per section number 103 or as per AOA, whichever is higher. Whichever is higher shall satisfy the quorum. Are you getting the point? Everybody? Yes? That means articles of association may provide for a higher requirement. Okay? Fine? Yes. Now, as per SS2, same thing was given in this board meeting also, SS1, that quorum shall be present not only at the time of commencement of meeting but throughout the meeting. That is while transacting the business also throughout the meeting. Yes, quorum provided in articles may be higher than what is given in the act. So this point is already covered here, right? Then that's it. Yes, proxies are always excluded while counting the quorum. Proxies are never counted in quorum. Okay. Now we know one more thing. If the member of our company is, if a shareholder of our company is a body corporate, President of India or Governor of State, if these people are the member of our company, if these people are shareholder of our company, and if our company is conducting a general meeting, okay, so now tell me in this case what will happen? Will these people come and attend the meeting? No. These people appoint an authorized representative. These people will appoint an authorized representative, and that authorized representative, he will attend the meeting. Correct? So if he attends the meeting, that is equal to these people have attended the meeting. Yes, deemed to have all the rights of member in person. This authorized representative will have all the rights of a member. Okay, clear? Yes. Then what if one person is authorized representative for more than one member? Come on. Suppose if there is one person who is suppose you are appointed as authorized representative for 3 companies. You are representing how many companies? 3 companies. Now those 3 companies are a member of my company. Now obviously those are companies, they are body corporates, they cannot come and attend the meeting, correct? So now who will attend the meeting? You will attend the meeting because you are authorized representative. Tell me, can you attend meeting on behalf of these 3 companies? Answer is yes. Understood everybody? Now tell me, that one person is representing 3 companies. That one person shall be counted as what? 1 or 3? When we count the quorum, while counting the quorum, that authorized representative who is representing 3 companies shall be counted as what? 1 or 3? Answer is 3. Answer is 3. Okay? We will see that now. Understood everybody? Yes. What you are talking about is joint shareholders. So don't mix the concept. We don't have to make cocktail here. Bas, now don't. Okay, fine. So, yes, because this authorized representative is attending the meeting, that is equal to as if those 3 companies are attending the meeting. Therefore, they will be counted as 3. Okay. So, here you can see one person can be authorized representative. See this, boss. One person can be authorized representative of more than one body corporate also. Clear? Okay. In such a case, he is treated as what? More than one member is present in person for the purpose of quorum. Means he shall be counted as more than one, but not one. Okay? Easy? Okay. Now one more thing. Yes, this part. Suppose our company ABC Limited is a company having number of members less than 1000. Okay, so tell me, what will be the quorum of our general meeting? 5 members must be personally present. Okay, but we called the meeting, only one person came in the meeting. Who is that one person? He is an authorized representative of 5 companies. He is representing 5 companies. Understood? Come on, now tell me, how many people are present in the meeting? 1 or 5? 1 or 5? I told you na, if this person is representing more than 1 companies, he shall be counted as more than 1 for the purpose of quorum. So tell me, how many people are present? 1 or 5? So he will be counted as what? 1 or 5? Array. Please focus. A person can be authorized representative of more than one body corporate, correct? So in my example, he is representing 5 body corporates, correct? In such case, he shall be treated as what? 1 or more than 1? More than 1 member is present in person for the purpose of quorum. So my question was, he is representing 5 companies, so meeting was called, he alone came in the meeting, no one else came, no other member came in the meeting. So tell me, if he is coming in the meeting, that means, tell me how many members are in the meeting? 5. What is quorum for our company? 5. So tell me, can we conduct the meeting? Why? Quorum is 5. Person who is present is 5. So why not? So tell me, how many more persons are required? How many more members are required? Only 1 more is required, because 5 are already there. Now tell me, if 1 more member is coming in the meeting, total number of members present in the meeting is how many? 6. Understood? Why? Because for conducting any meeting, at least 2 members are required to be present in the meeting. 2 persons are required in person to conduct the meeting. Understood? Pakka? Okay. So the question which I asked you, that is from your module only. Okay, that example is given here. The 5 body corporates. Right? Good. Yes, so proxies are always excluded for determining the quorum. I already told you, right? These all other examples, case laws. Yes, come on. Now, we were talking about quorum. What if quorum is not present within half an hour? So obviously meeting shall be adjourned to same day, same time, same place next week or such other day as decided by board. Okay, and if quorum is not present in a general meeting which was called by requisitionists themselves, in such case it shall stand cancelled. It shall stand cancelled. Easy? Okay. Can you see, chapter is very easy. We make it difficult by not studying on time. On time, that is very important. Fine. Next is chairman of meeting, section 104. I already explained you chairman yesterday. Okay, like every meeting have a chairman. What chairman does? Come on. What are the functions of chairman? General meeting. Come on. To call the meeting. Can he make the announcements of adjournment? Chairman can adjourn the meeting when the quorum is present as well as when the quorum is not present. Then he will announce whether quorum is present or not. He will adjourn the meeting. He will announce whether resolution is passed or not. Correct? Then roll call he will give. Then he will exercise his casting vote. Then, do you know there are different types of voting? One of the types of voting is voting by poll. So for voting by poll, that is section 109, you need to demand voting by poll. So who will accept or reject? Chairman. You can appoint a proxy. You can appoint a proxy. Who will accept or reject? Who will decide proxy appointment is valid or not? Chairman. I hope this is clear. Everybody, easy. So all these are the functions of chairman given here. Can you see this role of chairman and appointment of chairman? But I want to discuss something about casting vote. Everyone, all of you are aware about casting vote? Can chairman vote in the meeting? Chairman can vote only and only and only when votes in favor are equal to votes against. Okay, votes in favor are equal to votes against. Only in this case chairman can cast his vote. Otherwise, chairman cannot vote. Easy. Can I say chairman's vote is deciding vote? Chairman's vote is deciding vote. Because both the votes are equal, 5 yes, 5 no. So we need majority. So chairman's vote shall be deciding vote. Okay. One more thing. What if a person is a chairman of meeting as well as he is also the member of meeting, member of company? Come on. He is chairman also, he is member also. And here today he is attending a general meeting. So now tell me, can he vote? If yes, he can vote as what? Member or chairman? He can vote as member or chairman. Come on. He can vote as a member or he can vote as a chairman. Or he can vote as both. He can vote as both. But there are rules for this. There is a timing of that. He can vote as a member when the voting process is going on. Right? When all the members are voting, even he can vote as a member. Correct? Okay. Can he vote as a chairman as well? Yes. But he can vote as a chairman only when the voting process is over, plus there is equality of votes. Only then he will come to vote. Easy? Yes, easy everyone. So this is your role of chairman Chairman is required to be present if he is not appointed or is not present within how much time? 5 minutes was in case of board meeting and committee meeting. Here it is 15 minutes. So members present will elect any one of them as the chairman. No, they have said that the members present will appoint any one of them. Okay, fine. Who else can attend the general meeting? So as you know, notice of general meeting is sent to auditors also. Therefore here the reference is given of section 146. Okay, so friends, here, yes, so here you can see statutory auditor can attend the meeting. Yes, he himself or through his authorized representative can attend the general meeting. He is also entitled to receive the notice. Also he is entitled to participate in the meeting. Correct? Same way, secretarial auditor can also attend the meeting by himself or through his authorized representative. Now if these people are sending the authorized representative, that authorized representative shall also be qualified to be that auditor. Okay, that's all. And now we are moving to section 105, that is proxy. Yes, very simple thing. I already covered this topic, each and everything, in 11 points in my notes, if you remember. Do you remember all the points? We will follow the sequence of those points. Okay, so you can just concentrate. Obviously those points are in line of your module only. Okay, so firstly tell me, if a member cannot attend a particular meeting, can he appoint a proxy? Yes, he can appoint a proxy. So if he is appointing a proxy, okay, so first point was, who can appoint a proxy? Come on, who can appoint a proxy? Don't say member. You know what was the line? Any person who has right to vote and right to attend the meeting is also entitled to appoint a proxy. Okay, what line we are using? The member who has right to vote and right to attend the meeting is also having right to appoint a proxy. Everybody understood? First point. Come on, second point. What type of person can be appointed as a proxy? What type of person can be appointed as a proxy? Come on, is there any such rule that only and only a member of company can be a proxy? Can you appoint proxy to any person? Yes. But in case of Section 8 company, proxy need to be the member of company. Otherwise, for other companies, proxy need not to be the member of company. Then the appointment of proxy rules are applicable on which companies? Appointment of proxy rules are applicable in which companies? Company which is having share capital, and second, companies where AOA allows proxy to cast his vote. Only in this thing. Okay. Yes, and after that, next point we did was, as per my notes, was, can proxy speak in the meeting? Proxy have no right to speak, right? Can proxy vote? Proxy can vote, but only by poll. Only by poll. Okay. Now tell me, you can become proxy for how many members? Maximum how many members? Can you represent more than one member? Yes. How many members total? 50 members. So there are two conditions. You can act as a proxy for maximum 50 members, provided the paid up share capital holding does not exceed 10%. Understood? So in that case, that is the limit. 50 members is the limit, provided holding should not be more than 10%. You know what? If you are representing 40 members, is that allowed? Yes, 40 members is allowed. But you know, when we saw the holding of those 40 members, it was 11% of the paid up share capital. Is that okay? No. You need to satisfy both the conditions. And then, if you remember, I told you one more thing. What if there is a member of company and he himself alone is holding more than 11%, more than 10% of the total paid up share capital of the company? That alone member is holding more than 10%. So now tell me, can he appoint a proxy? Because as per the eligibility of proxy, we saw maximum 50 members and holding of those members should not be more than 10%. But here there is a member, he himself having more than 10% holding. Alone he is having more than 10%. So can he appoint a proxy now? He can appoint a proxy provided that proxy is a single proxy. Means that proxy now cannot further act as a proxy for any other member. Right? Fine. Then tell me how to appoint a proxy. Do you need to inform company in advance? Yes. You need to file this with the company. Which form? Form MGT 11. If you want to appoint a proxy, you need to appoint a proxy by filing form MGT 11. When to file that form? 48 hours before the meeting. At least 48 hours before the meeting. Is this clear to everybody? Okay, what if AOA prescribes the higher requirement? If Articles of Association says that for appointment of proxy, you need to file MGT 11 at least 60 hours before the meeting. Okay, the section 105 says 48 hours and our AOA says 60 hours. So we will follow what? 48 hours or 60 hours? 48 hours. Understood? Means 48 hours shall prevail. So here AOA cannot specify the higher requirement. Okay. Then when we appoint a proxy, company maintains the record of proxy, registers of proxy. So friends, can member go and inspect those records of proxy? Yes. Member can go and inspect those records of proxy, but for that you need to give advance notice to the company. You need to give advance notice of 3 days. You need to give 3 days advance notice and then you can go and inspect the records of proxy. But when you can go? You can go anytime during business hours, but you can go anytime but 24 hours before the scheduled meeting time. You cannot go after that. Means from the meeting time you need to calculate 24 hours. So 24 hours, earlier than 24 hours from the scheduled meeting time you can go. You know, I told you in class कि वो दरवाजे बंद हो जाते हैं 24 hours पहले, if you remember. So before that you can go, but not after that. Okay? So that was about inspection of the records of proxy. Next was a member who is filing MGT 11 for appointing a proxy. Come on, if I am a member of company, I have appointed a proxy by filing form MGT 11 for a particular meeting. Okay, but now that meeting is adjourned. Adjourned to same day, same time, same place next week. Now, do I have to again file MGT 11? No. No. But yes, read your book. Member is not required to file MGT 11 again because that meeting is adjourned. अभी बराबर आया, मालूम पड़ा. You understood? We appointed a proxy by filing form MGT 11. You appointed a proxy for a particular meeting and now that meeting is adjourned. So no need to file MGT 11 again. Easy? Fine. Then next we did was, yes, what if a member of company has appointed a proxy? So now who will attend the meeting? Proxy will attend the meeting. But after appointing a person as a proxy, member himself attended the meeting. Can he do that? Yes. So if member himself attend the meeting, now proxy shall be revoked automatically. Correct? Now proxy shall be automatically revoked. Easy, everybody? Any doubt in this? So now who will attend the meeting? Member will attend the meeting. So this was automatic revocation, right? But what if member appointed a proxy and member himself attended the meeting, and when he attended the meeting he saw that proxy has already casted his vote? Then then proxy cannot be revoked. Yes. Understood? And there was one more thing. This was about automatic revocation. But can member himself revoke the proxy before the meeting? He appointed a proxy because earlier he was like, I will not be able to attend the meeting. But later on, he is available on the particular day and time and place. So what he did before the meeting, he voluntarily revoked the proxy. Can he do that? Yes, by sending a notice to the company. Okay, this was the point. And after that, what if the member of company is, if the member of company is governor of state, president of India, or a body corporate? If these are the members of our company, do these people attend the meeting? No. They appoint authorized representative. So if these people are appointing an authorized representative, tell me that authorized representative is a member of company? No, he is not our member, obviously. He is not shareholder of our company, obviously, right? But now what happened? That authorized representative, he himself is not a member. He is representing someone, right? Tell me, is that authorized representative a proxy? Is he a proxy? Is he a proxy? Will he be treated as a proxy? Answer is no. Because authorized representative of any of the three is deemed to be the member present at the meeting. Okay, fine. Tell me, now that person, he himself is not a member. Now tell me, can that person appoint a proxy? Like, he's authorized representative, he cannot attend the meeting. Now he himself is appointing a proxy. He himself is appointed by someone else. And now he's appointing a proxy. Can he appoint a proxy? That person is having right to appoint a proxy. So answer is yes, because such authorized represent. Tell me, proxy. Come on, first point. What was the first point of proxy? Who can appoint a proxy? Every person who has right to attend the meeting, who has right to vote, has also right to appoint a proxy. So this authorized representative have right to vote in the meeting? Yes. He has right to attend the meeting? Yes. Therefore, he also have right to appoint a proxy. So that was the reason. In the first point, it was person and not the member. Just to avoid violation, contradiction with this provision. Everybody understood? Sure? Fine. And last point is about multiple proxies. You know, when we appoint more than one proxy, come on, what happens? Come on, if we have appointed more than one proxy, so which proxy shall be treated as valid? Last dated shall be treated as valid. Last dated. But what if the multiple proxies are appointed on the same day? Like in the morning we filed MGT 11, afternoon we appointed someone else MGT 11, evening one more MGT 11. So in that case you have to see the timestamp. The last timestamp will be final timestamp. Easy. So with this we have covered everything about proxy. Whatever is there in your module is done. Easy. This is a process of holding a meeting, how to conduct a meeting, notice and everything, procedure. And after this procedure, after 105, now here you will see types of voting, 106 onwards. Easy. Okay, so we'll go for a break because it's already 10:10. Then otherwise the break will be very at odd time at 11:30 somewhere. Fine, so we will meet after a few minutes. See you after small break. Hey, what 30 minutes? 15, 20, 15. Yes. So now different types of voting. Now before going to the voting side, let us discuss few questions. Yes. Chalo. You know this question? Come on. See. One question for practice. Yes. Chalo. So what is the question? AOA of XYZ Limited, okay, company having 700 members as on cutoff date, prescribe for physical presence of 7 members to constitute a quorum of general meeting. ठीक है, तो इस कंपनी में जनरल मीटिंग जो है इसके लिए कितना कोरम चाहिए? 7 एज पर इट्स AOA. इस कंपनी में टोटल नंबर ऑफ मेंबर्स कितने हैं? 700. करेक्ट. सो फॉलोइंग आर द स्टेटस ऑफ द पर्सन्स प्रेजेंट इन द जनरल मीटिंग ऑफ द कंपनी. Okay, to consider the appointment of MD. So let's check the quorum of the meeting. चलो quorum satisfy हो रहा है या नहीं हो रहा है? You need to check the quorum. Come on, tell me, all these people are present in the meeting. Okay, so who is the first one? Mr. A, who is representative of Governor of Maharashtra. Come on, tell me, will he be counted in quorum? Yes. Okay. Then he will be counted as what? 1, right? So okay, 1 person is present. First you tell me, in this given case, in this company's general meeting, what is the quorum? It shall be 7. कंपनी लॉ में ही लिखा है AOA में इतना होना चाहिए. कंपनी लॉ ही तो बोल रहा है ना कि quorum shall be as per 103 और as per AOA whichever is higher. दो आंसर थोड़ी होता है, एक ही आंसर होता है ना कोई भी. So obviously answer is 7. It is as per AOA, that is 7, or as per company law it is 5. So whichever is higher, Companies Act. So whichever is higher. The answer is 7. So 7 is the quorum. Now Mr. A is present, so he will be counted as 1. Then now Mr. B and C are preference shareholders. So will they be counted? Come on, will they be counted? Sorry? See, understand one thing. Here they are conducting a general meeting to consider the appointment of MD. So you know preference shareholders cannot vote in every resolution. Correct? So can they vote in this matter? No. So whatever quorum we say, so and so members must be present. Those are the members who are entitled to vote. So these members are not entitled to vote in this matter. Therefore, they will not be counted in quorum. Come on, next, Mr. D is representing ABC Limited and Sky Limited, two companies. He will be counted as what, one or two? Two. Now, Mr. E, F, G, H are proxies of shareholders. So, proxies are never counted. So, three members are personally present. And how much we need? 7. So, proxy is not a quorum is not getting satisfied. Easy? Yes. Only 3 members are present, therefore quorum is not getting satisfied. So, this was a practice question from your module itself. There are many more questions. We did this in class also from your module. Come on, tell me this. At a general meeting of a company, a matter was to be passed by passing special resolution. Out of 40 members present, 20 voted in favor of resolution. Out of 40, 20 voted in favor. 5 voted against it, and 5 votes were found invalid. So remaining 10 members abstained from voting, means refused to vote. The chairman of meeting declared the resolution as passed. Come on, tell me. Is the chairman's declaration valid? Yes. Is this resolution shall be treated as passed? Everybody sure? So see, here we need to pass SR. What are you saying? Bol. This is general meeting. See, we need to pass SR. What is SR? Votes in favor must be 3 times the votes against. Correct? So tell me, how many votes are in favor? 20 votes are in favor. How many votes are against? So are votes in favor 3 times the votes against? In such case, SR is passed. Simple. Easy? Fine. So this was also one of them. Therefore, declaration given by chairman is valid. Okay? Yes. Now, yes, let's go to the next section now, 106. That is types of voting. So, there are different types of voting, correct? Okay, firstly, this topic is starting from section 106, that is restriction on voting rights. So, generally, the rights of the members are never restricted. Voting rights of member are never ever restricted, but they can be restricted under 2 circumstances. First, call money is not paid, and second, when the shares are subject to pledge and the opposite party to whom the pledge was made, the opposite party is exercising his right of lien on that shares. So in such cases, rights can get affected. Otherwise, voting rights of the members are never ever affected. Okay, so this was your 106. It's only this much, very small section. Okay, next is 107. 107 is talking about voting by show of hands. So when will company conduct voting by show of hands? Firstly, what is voting by show of hands? It refers to one member, one vote. This is voting by show of hands. Okay. So whenever voting is conducted in a manner that is other than 108 and 109. Whenever it is conducted in a manner other than 108 and 9, then it is said to be voting is done by show of hands. Understood? So whenever it is other than 108 and 9, what is 108? E-voting. 109? Voting by poll. 110? Postal ballot. Easy? Therefore, voting by show of hands is a very common way to vote, very traditional way to vote. Yes. Now, what is next? Next is voting by electronic means, that is section 108. E-voting, voting by electronic manner, right? Now friends, it is not possible for all the members every time to come at the registered office of company and attend the meetings. So if they cannot attend the meeting every time, what happens is there is a reduction in participation of shareholders in voting. So in order to increase the participation, there is a concept of e-voting, correct? So now in e-voting, when will the voting conducted by electronic means? So for this you need to always remember rule number 20. Rule 20 of Companies Management and Administration Rules 2014, this always talks about applicability. It talks about what? Applicability, right? So means in which cases voting shall be done by electronic means. First, all companies whose equity shares are listed on recognized stock exchange, means for all public listed companies voting will be done by electronic means. And company having 1000 or more members. So company having 1000 or more members will also conduct e-voting compulsorily, right? So this is the applicability, and there is non-applicability also. There are few companies who are not required to conduct e-voting. Which are the companies? Actually, if you remember this, two, that is applicability, rest all will be non-applicability. But here you can see the list here. 108 is not applicable on Nidhi company, right? Then companies whose debentures and preferences are listed, right? In the previous case in applicability we saw equity shares are listed on recognized stock exchange, right? So if debentures are listed, preference shares are listed, but equity shares not listed, then e-voting is not applicable. Then companies which are listed on SME trading platform, companies which are listed on institutional trading platform, and so on. So all these companies are not required to follow this. Easy, right? That is e-voting. Okay, now can you see all these terms again? I hope you know, I already told you all these terms they can ask you in the form of, they will just tell you the meaning, what is cutoff date, explanatory statement, cyber security, electronic system. They can ask you all this. Secured system, voting by electronic means. These are very simple, but you will be able to write only after once you go through this. So please read this once nicely. They have asked this earlier in exams. Okay, now there is a procedure for e-voting. You can read the procedure. Next section number is 109, that is demand for voting by poll. Yes, what is voting by poll? One share, one vote. One share, one vote. And in the voting by show of hands, it was one member, one vote. So here, how much voting rights do you have? It depends on the proportion of your shareholding, correct? Now this voting by poll, when will you talk about voting by poll? So firstly, chairman of the meeting suo motu can conduct voting by poll, okay? Or it can also be taken up by the demand made to him by the following person. That means voting by poll shall be done. Yes, voting by poll shall be done when? By chairman suo motu, and secondly on demand made by the members including proxy. So who can make the demand? Who can demand voting by poll? Let's see. So if company is having share capital, in such case people can demand voting by poll. That is, who can demand? Members present or proxy who's having not less than 1/10 of the total voting power, or who's holding not less than 5 lakh rupees, okay, of the total paid up share capital, right? Yes. So this many people can request, can demand voting by poll. Who can accept or reject demand? Chairman, correct? We did that in functions of chairman. So this was the case where company is having share capital. For other companies means company is not having share capital. So if company is not having share capital, in that case what do we see? Voting rights. So in such case, member or proxy present having not less than 1/10 of the total voting power. Understood? So these people can demand for voting by poll. Okay, so chairman shall get the validity of the demand verified. Okay, now tell me, what is the time for taking the poll and declaring the result? Do you remember in very simple form we did in class? So generally poll shall take place within 48 hours from the time of request made, from the time of demand made, within 48 hours, right? But if we want to decide adjournment of meeting and appointment of chairman of meeting, if we want to decide any of these, in such case voting by poll shall be conducted immediately. So for these two cases, immediately. For other cases, within 48 hours from the demand made. Clear, everybody? So these are the two cases. Okay, so generally it is 48 hours. And for those two things, it is immediately. Okay, done. Then again here, voting by poll. Okay, do you know we appoint a scrutinizer? Scrutinizer means the person who is going to supervise, monitor the activity. He is going to make sure that the entire voting process is done in a transparent manner, fair manner. Correct? So company may appoint one or more scrutinizer by filing form MGT 12, proxy 11, scrutinizer 12. Okay? Is this clear? Captain is asking something. Will you cover each and every chapter in company law? I'm going to cover majority of the chapters, and yes, all the big chapters, which is very important chapters, because in company law there is something called as don't worry, we both are not on the same track. Don't worry. It is not important and not important. It is more important and less important, but all are important. You understood? So yes, I'm going to cover majority of the chapters, very important chapters, all the chapters, but you can also refer to the previous Sanjivani revision series. You may find few chapters there also, which I may not cover in this revision. But obviously we will cover all the very, very important chapters also. All very, very important. Okay, fine. So you need to appoint a scrutinizer. चलो ठीक है. हाँ नहीं ठीक है. चलो. So yes, so demand for voting by poll, MGT 12, you can appoint a proxy, this scrutinizer by filing MGT 12 also. Okay, then next is voting by postal ballot. What is this? Very simple, it is voting by post. It is voting by post or voting by electronic means. Right? Now friends, in this case, there are rules for this. There are few matters which you can discuss, you can conduct voting by post, and there are few matters which are not allowed to be translated by voting by post. Okay, so which are the matters which are not allowed? So you can see the list here. These two matters cannot be decided by postal ballot. Right? Yes. So which matters? Ordinary business cannot be decided by postal ballot. Second, business means any activity, any transaction is related to directors and auditors. You cannot decide these two matters by postal ballot. Is this clear to everybody? Yes. So these two things are not allowed, but there are also few things which are allowed. So which transactions can be transacted by postal ballot? For that you need to remember rule number 22. Rule number 22. Yes, rule 22 of Companies Management and Administration Rules 2014. So here you can see there is a big list given. Big list are given here, right? All these matters, all these matters you have already done somewhere in different chapters. Example, you can see alteration of object clause in MOA, right? In which, see, in case the company which is in existence before commencement of this act, alteration of main objects of the memorandum. For all these matters you need to take the approval of members. Right? So when you take the approval of members by passing OR and SR, you can conduct those voting by postal ballot. So these are the matters which are allowed, and the previous ones were not allowed. These two are not allowed. But what if we want to transact something which is not part of this list also, and which is not part of this list also? So what about those things which are not part of allowed list, which are not even part of restriction? So those transactions may be transacted by postal ballot as per the discretion of the board. Okay, so that is the point. And there are few companies which are not required to transact any business through postal ballot. Which companies are not allowed to use this method? One-person company and other companies having members up to 200. Sorry, why? Then कैसे? ऐसा इंटरप्रिटेशन मत करो, कंफ्यूज हो जाओगे आप. ऑल कंपनीज जहाँ पे नंबर ऑफ मेंबर्स अप टू 200. आप जो बोल रहे हो ना, वो तो मैक्सिमम लिमिट है. दिस ऑल कंपनीज जस्ट किसके मेंबर्स अप टू दिस मच है. ठीक है. Yes, चलो. Now again here you can see the procedure कैसे होता है postal ballot. So again procedure आपको read करना है, being a revision class. Then next जो है section 111. This is connected with 115. What is 115? Special notice. आपको पता है company for conducting general meeting, company may give special notice for certain agendas. There were 4 things: removal of director, appointing the new person instead of the removed director, removal of auditor, appointing the new one, right? But also we did that members can request the company for sending special notice for other matters also. Members holding 1% total voting power, or members holding 5 lakh rupees of the total share capital. Yes, so we did that, correct? But here what they are saying is, when they send the notice, do you remember in this there is only 2 things when that notice shall be sent. So one is not less than 6 weeks and another is not less than 2 weeks. Can you see that? The copy of request signed by the requisitionist is deposited to the company. In case the request is for the matters under section 115, the notice shall be sent 6 weeks before. But for other matters, if the request is made for any other than 115 matters, then it shall be sent 2 weeks before the meeting. Okay, so this only 2 things, 6 weeks and 2 weeks. Only this much you need to keep in mind. Okay, nothing else is there in this section, it's over. Next is 118 minutes book. I hope all of you have seen yesterday's class. In yesterday's lecture 118 we have already done the detailed procedure, right? Here you can see the similar thing. Companies Act 118 remains the same. Here we talk general meeting point of view, and there in board meeting we see board meeting point of view, but minutes are minutes. Can you see the separate book shall be maintained, maintaining the minutes book, preservation of minutes book shall be preserved permanently. We have done all this and it's over. But in board meeting chapter module it is given in detail. Okay, here you can see only this much and it's over. See, the next topic starts here. But in board meeting chapter module it is given in detail. If you have not seen the video, please go and watch that first. Okay, next is, see this topic, report on AGM. You know friends, this topic is not yet asked in exam. So there are chances that they may ask you. Report on AGM. See, what is this? Firstly, this is for which companies? This is for only public listed companies. So friends, for every public listed companies, they have to prepare a report. They have to prepare a report on each AGM. They have to prepare a report on each AGM. Okay, means after the AGM is over, they have to prepare a report. So is this minutes book? No, this is in addition to the minutes of general meeting. It is addition to that. So every public listed company have to prepare a report and file this report with ROC in form MGT 15. Are you getting the point? Yes, MGT 15. I hope this is clear to everybody. So every public listed company will file a report on AGM in form MGT 15 within 30 days from the conclusion of AGM along with the prescribed fees. Okay, and what other rules are there? This report on AGM shall be signed by the chairman of meeting. If he cannot sign, it shall be signed by the 2 directors, one of whom shall be MD, okay, and also company secretary of company. So they will sign it. Come on, first thing, it is addition to minutes. It shall be signed by chairman or 2 directors, one of them shall be MD and CS. It's and CS. Okay. Okay, report shall contain what all things? So report shall contain the following things, that is date of meeting, time of meeting, place of meeting, AGM, right? Then appointment of chairman confirmation. Yes, chairman was appointed in this meeting, so and so person was the chairman. The number of members attending the meeting. Then confirmation for quorum, that quorum was satisfied. Then confirmation with regard to compliance of the act and rules for calling the meeting, conducting the meeting. That means meeting was called as per the act and rules and SS2. What business were transacted in the meeting, right? Details with regard to adjournment of meeting, postponement of meeting, change in the venue. Basically all the details, any other relevant points. Easy. Basically report shall contain fair and correct summary of the AGM. Okay, and last thing is, if company fails to file that report, in which form? MGT 15, within 30 days from the conclusion of AGM. Which company? Public listed company. Correct? So if company fails to do so, there will be a penalty. Yes, penalty shall be imposed on company, that is 1 lakh rupees, and if the default continues, further fine of 500 per day. 500 per day, subject to maximum 5 lakhs. So you need to note down this much penalty on company. Okay. Now officer in default. Officer in default shall be penalized with fine of not less than 25,000 rupees. If it continues, then further fine of 500 per day, subject to maximum 1 lakh. For companies, maximum was 5 lakhs. For officer in default, maximum is 1 lakh. Further penalty 500 per day, same for both. For company, minimum fine is 1 lakh. For officer and default, minimum fine is 25,000. I hope this is clear to everybody. Yes? Done. Then we have duties of CS. We did this yesterday. Duties of CS: before the meeting, at the meeting, after the meeting. Yes, yesterday if you remember I went through all the lines also. So when you do this type of chapter, you need to determine what all are the activities which is to be done before the meeting. Like sending notice. If it is short notice meeting, you need to take the consent of 95% of total number of members. So all these are prerequisites from calling a meeting. Correct? Then at the meeting, what you will do? You will help the chairman to conduct the meeting. You will see whether quorum is present or not, all those things. And after the meeting, minutes book. You follow the minutes book procedure. Yes, and then we have virtual meetings. Yesterday we did virtual board meetings. Today we are doing virtual general meetings, right? So very simple thing is given here. Large number of shareholders are involved in the general meeting process, but all the shareholders cannot attend the meeting, which leads to decrease in their participation in voting. Correct? So with the help of virtual meeting, maximum shareholders can participate in voting now. Correct? They can attend the meeting. So this is the introduction of virtual meeting, and here are few advantages of virtual meeting and difficulties in virtual meeting. What are the advantages? All the points talks about two things. First, increase in participation. Second, it saves time and cost. Understood? It saves time and cost. So all the points will talk about this only. See this. Increase shareholder participation. It saves time on travel and cost. Encourages more participation. Again, increase in participation only. Right? It provides greater accessibility to shareholders. Means more shareholders can participate. Right? It enables the institutional investors to attend more than one meeting in a day. They can attend more than one meeting in a day because it is online meeting. Again, reduce the cost. Okay? And saves times of company personnel also. It saves the time of company people also. So these all things. And what are the difficulties? Difficulties are only similar thing, that is technology issue. Many shareholders, many members are not familiar with technology. Everybody don't have adequate internet, adequate devices. They are saying that you need a laptop or a computer or a leased lines. See here, you will see the list of that also. What are the prerequisites? So leased lines, you need to hire this, or you can rent it. That leased this software, like we use Zoom and other softwares. So you need all that, right? Then if the passwords are leaked out, so unauthorized people can also attend the meeting. These all are the difficulties, right? And after this, here there are one, you can see case law, and then your chapter is over from module. Okay, so these are few practice questions, and here the drafting part starts. Once again I will say we have a drafting lecture uploaded on our this YouTube channel. Please go and watch. Drafting is now one of the compulsory questions, so please don't take it lightly. Okay, all these are the drafting practice and then lesson roundup. Okay, so finally in this Sanjivani we are done with how many chapters total? 3 chapters: board meeting, general meeting and KMP. All 3 are very important, right? Fine. So what's next? Next. Charges, such a easy chapter. It's a very easy chapter, charges. Fine. See, obviously I'll tell you what we are going to do. See, we are going to do share capital. Not now, when we start the class. Share capital is one of the chapters which we are going to cover in this revision series. We are going to do debt instruments also. Okay, it's very easy. You want me to do? I'll do it. Okay, then we are going to do general meeting is done. Yes, we are going to do directors, board meeting is done, general meeting is done, KMP is done. Okay, so these are the chapters confirm we are going to do. We will do more chapters if time permits. Okay, or also you can see the previous Sanjivani revisions, right, for other chapters like accounts and audit. It is already covered earlier. Members and shareholders also covered earlier. Otherwise, see, all these chapters are very comparatively easy. Yes, about drafting, but I told you drafting is one of the compulsory question now. Earlier it was optional question. So please don't ignore it, and drafting lecture is already uploaded on our this YouTube channel. You can just search. You will get it. Okay? No, no, it is there. Yes, बेटा ड्राफ्टिंग लेक्चर इज देयर. आपको थोड़ा स्क्रॉल करना पड़ेगा. इट इज अपलोडेड, थोड़ा पहले है, थोड़ा स्क्रॉल करो. हाँ, कंपनी लॉ ड्राफ्टिंग लिखा है. ओके, यस. चलो फिर अभी क्या स्टार्ट करें. बचा लोग समथिंग इंटरेस्टिंग. चलो, सो चैप्टर्स ऑब्वियसली हम करते रहेंगे, बट लेट अस डिस्कस क्वेश्चन आंसर्स. ओके, बहुत मजा आएगा. आर यू ऑल रेडी यूट्यूबर्स? यूट्यूब. Let us discuss few past exam questions as we have less time right now today. Okay, so tomorrow we will start with the new chapter. अच्छे से कुछ चालू करेंगे. Okay. Okay, I'll do one thing, beta. All the people who are searching drafting lecture, I will drop drafting का link in this video का comment. Okay, मैं comment में आज डाल दूंगा link. Don't worry. लेकिन आप लोग इस वीडियो को लाइक कर देना. नहीं, जस्ट किडिंग. अच्छा लगे तो लाइक करो, नहीं अच्छा लगे तो मत करो. चलो फाइन. सो लेट अस डू क्वेश्चन आंसर्स. Okay. Question is coming from June 24 paper, and chapter is coming from chapter General Meetings, which we did just now. Exam question है, आप देखो. अभी आपको सुनने में you will feel अरे question is so easy. If you know the chapter, all questions are easy. If you don't know the chapter, everything is difficult. So question is, everyone is ready? YouTube, will you answer in the chat box? Yes, you need to type a bit faster. Okay, let's go. Question is, explain the compliance requirement for holding AGM of the company, including listed company, one-person company, as per the provision of Companies Act 2013 and applicable regulation of SEBI LODR. Okay, 2015. Come on, you need to explain the compliance requirement of AGM of the company, including listed company, as per Companies Act, and also for one-person company. Okay, come on, who is going to answer about, come on, first AGM. You need to explain the requirement for AGM. That means you need to write the rules related to conducting AGM. So first AGM within 9 months from the end of first financial year. Superb. Then what about this one-person company? One-person company are not required to conduct AGM. Fine. Then what about listed company? First AGM. First AGM for listed company. You know, for listed, that is 5 months rule was applicable for top 100 listed companies, not for all. But you can write that as per SEBI LODR. But it is removed, no? Right. Fine. Chalo, this is one thing. Then AGM must be conducted every year. You have to write in each calendar year. In each calendar year. Sorry. That we will talk after 15 months gap point. So first AGM is done. Come on. Second and subsequent AGM, 6 months from the end of every financial year. Right? Gap between two AGM shall not exceed 15 months. However, you can apply for extension of gap, that is with the permission of ROC. But not exceeding 3 months. Easy? Huh? You can write that point. Do you know that the AGM is not required necessarily to be conducted in the year of its incorporation? We revised that today, right? Chalo, great. Then about extension of gap, maximum 3 months with the approval of ROC. Then we spoke about listed companies also, top 100 listed company, fine. Then OPC exemption, yes, everything we have answered. Sorry? You can write that if you want, because they have not specifically asked about what they want. They're talking about frequency of what, so you can write that, no problem. Okay, but make sure, so tell me just one thing, question was easy? June 24 paper. It was asked for 5 marks. Understood? Easy na? If you know the chapter, everything is easy. Don't skip anything. This is the way they have made the question. What is difficult in this? They are directly asking you explain this. It's not that. The problem is we are not practicing enough how to draft the answers. That is a problem. See, just now when I gave the hint, everybody started. Okay, fine. Chalo, can we move to the next question? Yes. Okay. Something interesting. Chalo, chalo, chalo. See this. This question was asked for 4 marks in June 2019 exam. As a CS referring to the provisions of Companies Act 2013, examine the validity of the following propositions. Okay, few activities, few decisions were taken in the company. You need to explain whether these things are valid or not. First, company wishes to call its AGM, annual general meeting, on a working day at 6:30 p.m. Any problem? It should be only during business hours, and business hours means 9 a.m. to 6 p.m. Superb. Next, second, what they did. Due to availability of chairman, AGM of company can be held only on 15th August 2018. All members are ready to give their consent. All members are ready to give their consent in writing in advance for the same. Any problem? Do you know the day of AGM? AGM can be held on a day other than national holiday. Here they are talking about 15 August. Understood? Therefore, it cannot be held on 15 August. Then, due to technical problem, company wants to hold its AGM at a city other than a city at which the registered office of company is situated. Come on, what do you think? This is about the place of AGM. So what do you think? What is the rules for the place of AGM? AGM must be held at the registered office of company or any place within the same city, town, village where the registered office of company is situated. Correct? So if company but in the given question they are conducting AGM at a city other than the city where the registered office of company is situated. So can they do that? They can do this only with the permission of central government. Otherwise, generally it is not allowed. Easy? See, this question was asked about date, time and place of AGM. 4 marks. Exam question. Easy, na? She'll tell you how you should write this answer. See, in a given question, if you see there are sub-question asked. So can I say all the 3 are connected with AGM only? So what you should do, you should first write provisions, common provisions regarding AGM, date, time, place. Then while you write the conclusion, you can give first point, conclusion for the first question. Second point, conclusion for the second one. Third, conclusion for the third one. That way you can draft. You can write common provisions because all the 3 are connected with the same thing, that is AGM. So that way you can first write common things and then later on you can conclusion, you can write point wise. But in the many cases you will see that the 3 questions are not belonging to the same section. So in that case you have to write provision, conclusion, provision, conclusion. That way you can write. Both are correct. Okay? Yes. The next question. Okay. This question is coming from question paper of December 2020. Okay. CS Executive December 2020, 4 marks. 25 members of a company 25 members of company holding 11% of the total paid up equity share capital has made a requisition on 5th December 2019 to Board of Directors to conduct EGM. You understood? See, how many members? 25 members holding 11% of total equity paid up share capital. What they did? They made a request. They made a request to call EGM to Board of Directors on 5th of December. They made a request to call EGM on 5th of December. Okay? Yes. Now, state the date by which Board of Director is required to proceed to call the meeting and the date by which EGM should be held. You understood? So you all know the provisions, right? Section number 100, we say that EGM can be called by whom? So firstly, meaning of EGM. All general meetings other than AGM are called as EGM. EGM can be called by board as board deems fit. Second, by board on requisition of members. Third, requisitionists themselves. And lastly, by tribunal. So for this particular question, obviously it's a case study question. So in that, first you will write provisions. In provisions, you always have to start with section number, right? And here you are going to write obviously in points. And here you are going to explain EGM, meaning of EGM and calling of EGM. Who can call EGM? There are total 4 points. Here you are going to write 3 points. First 3. Because in the given question they are not talking about calling of EGM by tribunal. Here they are calling about EGM, which is they made a request to board for calling EGM. So what are the rules for that? So you have to write the provisions here. I hope you know how to write provisions. In provisions, what are the rules? You never have to try to write conclusion. Don't try to conclude your answer. Always write only the things which are written in the section. Don't try to conclude. Don't use the characters given in the question. Like here you can see the name of the company must be given ABC Limited, whatever. Don't write the name of the company when you're writing provisions. Because in provisions you are saying as per section 100 of Companies Act 2013, then you write the points. So in those points, if you write ABC Limited, tell me, is ABC Limited, this word is used in the section 100? No. So how you can write that? So provisions you need to draft in points. Your provisions must be strong enough to support your final answer. Whatever is your final answer, in this question you saw they are asking you the date by which board have to proceed to call the meeting and date by which board have to conduct the meeting. So you don't have to write the dates in provisions. I hope you know that. You will write all those things in the conclusion. Okay, so here you just explain your EGM, calling of EGM, point number 1, 2, 3. Like EGM, request shall be made by the members holding 1/10 of the total paid up share capital if company is having share capital. If company is not having share capital, then members having not less than 1/10 of the total voting rights. They will make the request. Then board shall proceed to call the meeting within 21 days and board shall conduct the meeting within 45 days from the date of request made. So you will write all this and then you also write the third part. That is, if board fails to conduct the meeting within 45 days or fails to proceed to call the meeting within 21 days, in such case requisitionists themselves shall conduct the meeting within 3 months from the date of request made. You write all the 3 because third point is important because we are writing the consequences also. So write all this and then you will write facts. In the facts you just have to copy the situation from the question and then finally the conclusion. You know what are the rules for writing conclusion? When you write the conclusion, always start as per the above provisions. Whenever you write the conclusion, always try to give your final answer. And don't just write, yes, given statement is correct. Don't write all this. Whatever they did is correct. It's incorrect. Don't do all this. Firstly, try to improve your vocabulary. Right? Like don't, instead of writing, the given statement is incorrect, you can say the act done by them is not tenable, not justified. Such words should be used. Then give your final answer. Use the characters given in the question. And whenever you write the final answer, let's say you're writing the given statement is correct. If you write this, it is not wrong, but it's okay. So if you write the given statement is correct, don't just write this line. You should also explain the reason. In short, in brief. Why do you think it is that? Connecting to the provisions. Right? So these are all other rules. Come on, so in this particular question, they have asked you the date by which board shall proceed to call the meeting and date by which board have to conduct the meeting. Okay? And question also says one more line. That what should the requisitionist do if board fail to act on the requisition? So already we have covered the third part in the provisions. That requisitionists shall conduct the meeting by themselves. Correct? So come on, here the date you need to give. So you will calculate board shall proceed to call the meeting within 21 months. 21 months from 5th December. That is the date when the request was made. And conduct the meeting within 45 days. 45 days from 5th December. So that is all what you need to write in your conclusion. Everybody understood? Easy question. They asked you for 4 marks. Yes, in conclusion you will write the date, no? So you just have to write the date. You can write, explain, that is, this is 21 days from the date of request made. You can write that. Yes. Bolo, bolo. See the next question, very nice question. This question is coming from December 22 question paper. December 22. Okay. Question says that in general meeting of CBD Limited, in a general meeting of CBD Limited, 6 individual members were present. 6 members were present. Okay. And the meeting was adjourned by the chairman of the meeting at his own will. Chairman adjourned the meeting at his own will. Okay. To the same day, next week. Why did he adjourn the meeting? As important member was not present for the meeting. Okay. So in this context, referring to the provisions of Companies Act 2013, answer the following questions. Okay. You understood? Okay. First question. Could chairman adjourn the meeting if company's shareholders, the total number of members strength was 300? You understood? Total, how many members were present in the meeting? 6. What are the total number of members in the company? 300. Chairman adjourned the meeting. 6 members were present. Still adjourned the meeting. Chairman adjourned the meeting. Why? Because important member was not present at the meeting. So, could chairman adjourn the meeting if company's shareholders, the total number of members are 300. Come on, if total number of members are 300, what shall be the quorum? 5 shall be the quorum. Present members are 6. So, quorum is getting satisfied. Can he still adjourn the meeting? Can chairman adjourn the meeting even when the quorum is present? He can do that with the consent of the members of company. Yeah, so therefore it is incorrect. He can adjourn, but with the consent of members, not at his own will. Understood? Easy? Just now I told what you were doing. Wait. You understood the answer for the first one? Second sub question is, for the adjourned general meeting, is any fresh notice of meeting is to be sent? Any fresh notice is to be sent for the adjourned meeting? Yes, you know that. Yes, you need to first see the meeting is adjourned for how much time. If the meeting is adjourned for less than 30 days, then you can send the notice of, you have to send the notice of at least 3 days in advance. Or you can also publish it in the form of advertisement in the 2 newspapers, English and vernacular. And if the meeting is adjourned for 30 or more days, the entire 21 days notice shall be sent. Correct? This was the second one. And the third one is, if only 3 members were present in the adjourned meeting. Meeting was adjourned. Now in the adjourned meeting only 3 members were present. Okay. And again, in that meeting too, important member was not present. Could meeting be considered as duly conveyed and conducted? Can they conduct this meeting? Only 3 members were present in such meeting. Which meeting? Adjourned meeting. What is the quorum for this company? 5. How many members were present in the adjourned meeting? Originally the meeting was adjourned for the want of quorum. Now in adjourned meeting also quorum is not present. So can they continue with the meeting? Only 3 members are present. Quorum is not getting satisfied. Can they continue the meeting? If the quorum is not present in adjourned meeting also, in case of general meeting, the number of members present shall form the quorum, provided they are not less than 2. Easy. This question was asked in exam for 5 marks. Easy question. So if you know the chapter, everything is easy. Don't skip anything, all chapters are important. Okay? Yes, tell me what you were asking me. Just now I told that only, you were not paying attention. I guess I told if there are sub questions and all the questions are related to same section. So you can write provisions in common, covering the conclusion for all. So you will explain, give the proof of covering all the 3 questions. So after writing a common provision, then when you write the conclusion, so conclusion mein you can give the headings, first point, first conclusion, second point, second conclusion. As per the above provisions, you can just write the conclusion point wise. But in many cases you will see that the questions asked are not covering the common section. So in that case you have to write provision, conclusion, provision, conclusion, provision, conclusion. Okay, done. Easy. So yes, we will continue this revision class tomorrow 8 a.m. So everyone please be present. Tomorrow we'll start with some new chapter. Okay, thank you so much. Keep learning everyone, keep revising. All the best. Bye-bye.